From Virginia, Mr. Griffith, for 5 minutes.
Thank you, Mr. Chairman. Appreciate you having this hearing very much. I rarely disagree with my colleague from West Virginia, but in this case I do. The process and the procedures by which we get our laws and pass our laws may not always make sense or be practical in the minds of some, but it is what has allowed our republic to exist for the length of time it has, over 200 and, I guess we're closing on 220 some plus years, and it is extremely important. Professor Revesz, I love these things, and I'm going to go down a different rabbit hole than the one we've been going over, although I'm coming back to that one because I love that one too. The proposal that you make is a parliamentary procedure impossibility. It cannot happen. It doesn't matter what the issue is. Jefferson's very clear in the Manual of Parliamentary Practice. When there are differences between the two houses, they get together in a conference and they work those differences out. If both houses adhere to their position, the bill itself dies. It's not for you to say today that the bill should die if there's some confusion because there are two different versions. There are not two different versions. There is one version. It could not have passed out of both houses, gone through a conference committee, and gotten to the President's desk unless there was one version and one version exclusively. And then we get to the point that Professor Tribe made, and it is an honor for me to be in your presence. We're not always going to agree. There's a lot of things we're going to disagree on politically, but your defense of the Constitution, I'm 100% behind and agree. And even when the rules in the Constitution are against me on what I believe ought to happen, I respect that those bodies and those rulings must be followed. And so we get to that because I think that if there was some kind of a disagreement and suddenly it's found 25, 30 years later, that creates a problem. And I would submit, I don't know about the 1995 ruling, and I would ask you quickly if you could tell me about that. You said that it had already been determined in 95, 8, and 11, and I know 8 and 11.
Right. Well, in 1995, the EPA itself interpreted the Section 111D, as I have, and as I think the courts would. Okay.
And then we get to 2008, and you didn't make this point, although I'm sure you're aware of it, and I find this language fascinating, and brought this up to the EPA months ago. That decision, if you read it, part of it says, this requires vacation of cameras regulations for both new and existing EGUs, electric generation units. EPA promulgated the camera regulations for existing EGUs under Section 111D. This is a court opinion by the Circuit Court in D.C. Listen to what I'm saying here. For existing EGUs under Section 111D, but under EPA's own interpretation of the section, it cannot be used to regulate sources listed under 112.
Right.
The judge found that they had conceded, and he goes on to say, EPA thus concedes that if EGUs remain listed under Section 112, as we hold, then the camera regulations for existing sources must fail. The EPA appealed that ruling, but not on that point. Now, what's significant about that, and the question I have for you, and I'm going back to first-year law school for myself, is the EPA now precluded under either the theory of res judicata or collateral estoppel, having conceded the point in the 2008 case and not appealed at the Supreme Court, and having been a party in that case, albeit not a party in the 2011 case, have they conceded the point, and are they now thrown out on their backsides because they've already conceded this point, and to bring it back up is a waste of time, as Mr. McKinley said?
I think because that case was New Jersey v. EPA, it's only New Jersey that could make that collateral estoppel argument. Other people confronted by an EPA that says we have now changed our minds, like Robert Jackson once said, the matter does not appear to me now as it appears to have appeared to me then. Other people are not going to be able to stop the EPA.
But I would
so the EPA is free to make these arguments. I just think they're wrong and will lose.
All right. And you think they will lose also in looking at 2011, although they were not a party to that. You were correct in referencing footnote 7 that said that the Supreme Court specifically said in their opinion, previously cited approvingly by Professor Revesz, that there is an exception. EPA may not employ 7411D, which is what we're talking about, if existing statutory sources of the pollutant in question are regulated under the National Ambient Air Quality Standard Program 74087 through 74110, or the Hazardous Air Pollutants Program 74112, which is what we're talking about is 111 and 112. Am I not correct?
Correct, and that use of the word "or" supports the court's reading. The courts have been consistent in accepting this reading all this time, and it is amazing, though it's not illegal as such, for the EPA to scratch its head and say, how are we going to win this case? We got to invent a new statute.
And they've reached pretty deep to find something that they could hang their hat on.
They reached very deep to something that Senator Durenberger, when it was first proposed, said, I can't imagine this being used very often. It's only been used 5 times. It's a technical little, well, it's a mouse hole, and they're pulling an elephant out of it.
Thank you. I have to yield back. I wish I had more time.
Gentleman yields back. Thank you. At this time, recognize the gentleman from Maryland, Mr. Sarbanes.